everyone, and welcome to CLRNN Conversations. Today, we continue our conversation with Professor Paul Idornigie, SAN, on commercial law reform in Nigeria. If you haven't, please see our previous conversation on the commercial law reform framework and the CAMA 2020 reforms. Professor Idornigie, SAN, is an award-winning scholar, senior advocate of Nigeria, and law reformer who has contributed considerably to the development of the Nigerian commercial law. Professor Idornigie, SAN, has lectured at various colleges and universities in Nigeria, including, notably, the University of Jos and the Nigerian Law School, Abuja. He held the SMA Belgore Distinguished Chair as a Professor of Law at the Nigerian Institute of Advanced Legal Studies, Abuja. At the Institute, he also held several other roles. He was the head of Department of Commercial Law and Alternative Dispute Resolution. He was Director of Research and Director General. He has taught and published extensively in local and international journals on ADR processes, company law, company secretarial practice, public finance, constitutional law, international economic law, investment law, investor state dispute resolution, law reform, and private sector participation in infrastructure delivery. I would like to slide in a note here to stay tuned for our conversation with him on the BPE, which comes after this. Professor Idornigie, SAN, was also previously General Counsel and Head of Secretariat, Bureau of Public Enterprises, BPE, Abuja. And in that role, he was involved in the first draft of the Petroleum Industry Bill in 2005, between 2005 and 2008, the unbundling of the National Electric Power Authority, NEPA, into the initial holding company, Power Holding Company of Nigeria, PLC, and subsequent transfers to generation, transmission, and distribution companies. Also the privatization of LMA Petrochemical Limited, Transcorp Hilton Hotel, the concession and lease of the port terminals in Lagos, Warri, Port Harcourt, and Calabar, amongst other public enterprises. Professor Idornigie, SAN, continues to practice in commercial and investment treaty arbitration, either as counsel or arbitrator. Out of the 5 production sharing contracts that the Nigerian National Petroleum Corporation, NNPC, executed with the international oil companies in 1993 that resulted in arbitration, he was involved in 2 of them as party-appointed arbitrator. Similarly, he was a counsel in the International Center for the Settlement of Investment Disputes, ICSID arbitration, involving the Federal Republic of Nigeria and Shell Nigeria Ultra Deep Limited, the OPL 245 Malibu dispute. You're welcome again, sir.
Thank you very much. It's nice chatting with you again this morning, Bolanle.
Thank you, sir.
Okay.
In our first of this series of conversation, we invited you to give us insights into the black box of commercial law reform in Nigeria. And in that conversation, we used the recent reforms to the Companies and Allied Matters Act, CAMA 2020, as our entry point. Today, we examine the constitutional issues, the thorny constitutional issues that impact commercial law reform in Nigeria. For those who may be unaware, Nigeria has a federal system of government with 36 states and the federal capital territory, Abuja, with a written constitution that divides powers between these levels of government. Can you provide us with a quick overview of the constitutional division of lawmaking powers in Nigeria, stating how each level of government is provided with the right to make law?
Yeah. Thank you very much. I think you set the tone for this conversation, because Nigeria is really a federal republic and has a written law, unlike a place that the UK that they do not have a written law. We have we are in a federation with a written law. Now, in a federation, powers is shared between the federative units. Now, in the case of Nigeria, we have three organs of lawmaking. We have the National Assembly, we have the State Assembly, we have the local government. But in our Constitution, powers to make laws are shared between the federal government and the state government. There is no provision for local government in our Constitution to make laws. I'll talk about where they derive their powers to make laws there subsequently. So if you look at Section 4 of the 1999 Constitution that I will hereafter be referring to as the Constitution, you find that it provides that the powers to make law of the Federal Republic of Nigeria is vested in the National Assembly that is made up of the Senate and the House of Representatives. So at the federal level, we have a bicameral legislation. As you find out shortly, at the state level, we have a unilateral legislature. Now, the powers to make laws that is vested in the National Assembly is to make laws for the peace, order, and good government of the Federation or any part thereof, the federal government or any part thereof, with respect to the exclusive list. Again, as I'll go on with this conversation, I will show that in the schedule to the Constitution, there are two lists: exclusive legislative list and concurrent legislative list. Now, the exclusive legislative list is a list reserved for the National Assembly to the exclusion of the state assemblies. I take that again. The exclusive list is a list for the National Assembly. So in that list today in Nigeria, we have 68 items. That's why people are talking about devolution. And as you find out shortly, in the concurrent list, we have only 30 items. Now, if we are saying that it's a federal republic, why should the federal government have 68 items to make laws on, and there are 30 items that the federal government shares with the state government? So we have the exclusive list that is reserved for the federal government. The state assemblies cannot make laws on those 68 items there. Now, the concurrent list is a list that is shared by the federal government and the state government. So on matters in the concurrent list, both the federal government and that is the National Assembly and the state assemblies are competent to make laws of them. Now, we see, let me start with the problem with our kind of federation. We have Section 4, Section 5, that provides that when the state assembly makes a law on the subject matter in the concurrent list, and the National Assembly also make laws on the same matter on the concurrent list, the laws made by the state assembly are void to the extent of their inconsistency. I ask this question: if you are saying that we're only a federation and powers are shared, why should the laws made by the federal government take precedence over laws made by the state government? We're talking about this principle of covering the field, the principle of covering the field. I think that this principle is not favorable to a country like Nigeria. But I repeat, if we are saying that powers are shared by the National Assembly and the State Assembly, why should the laws made by the Federal Assembly override laws made by the State Assembly? I think that is part of our problem in our kind of government. I think that we need, if we really want to run a true federation, we need to look at that issue again. And the word, I find the word very interesting. It says a law made by the State Assembly, then a law validly made by the National Assembly. So does it mean the one made by the State Assembly is not validly made? So I don't understand why they should qualify one as validly made and the other as not. Whereas constitutionally, both chambers, i.e. National Assembly and the State Assembly, have powers to make laws on them. Now, although the Federal National Assembly, in this case, and the State Assembly have powers to make laws, they cannot make laws that house the jurisdiction of the courts. They cannot. They cannot make laws. So they have powers to make laws, but it's not at large. In fact, their powers to make laws are limited to the provisions of the Constitution. Now, lastly, when they make laws, the laws cannot have retroactive effect. Remember, during the military regime, you may be walking along one street, not an offense, but as soon as they target you overnight, a decree is out, is backdated. And I'm sure many of us will remember the trial of Chief Olabode George. Olabode George was chairman of Nigeria Post Authority, and he made a procurement. He was alleged to be splitting contracts. Splitting contracts. You know how it works is, as an organ of government, you have a threshold. In other words, you cannot award a contract beyond 10 million. That's your threshold. So what happens in practice, if you have 50 million contracts to award, they just feed it to 9,000, 9,000, 9,000, 9,000. That is what happened in FPA. And Olabode, again, he was a very strong member of the ruling government. I think he fell out of favor and he had to prosecute him. That he was guilty of that government regulation. And one thing I like about our constitution is, if you look at section 36 sub 12, it provides that no act is an offense unless there is a written law defining an offense and prescribing punishment. Now, Olabode George was charged under a regulation. A regulation is not an act. But he was charged before 2007. By 2007, we had a law called Public Procurement Act that now makes splitting of contract an offense. They tried to charge him for that offense. In fact, they charged him for that offense. That's why he was discharged. Supreme Court said, at the time he was alleged to have committed the offense, there was no written law defining the offense of splitting. And so he could not have been charged under a law that was non-existent. So it's a very fundamental principle for our law that you cannot be charged for an offense unless there's a written law defining the offense and prescribing punishment. That takes me to, like I said, I'll be talking about the federal government, state government. I think there are 3 tiers of government. Let's come to the local government now. And I find this very, very interesting. Section 7 of the Constitution provides that every state should make laws to regulate local governments. And the word used in the Constitution is that the system of local government by a democratically elected council is hereby guaranteed. I say that again. The system of local government council that is democratically elected is hereby guaranteed. Now, despite this provision, you find governors dissolving these councils and appointing caretaker committees. This same governor swore to defend and uphold the Constitution. No governor has powers to dissolve a local government council, except the powers are expressly in the law. Even if they do, they cannot appoint administrators. And lately, I think on the 7th of May this year, Supreme Court declared such act by Oyo and Katsina State government as clearly illegal, and that all those facts should be paid. They should pay their arrears. So, but again, if you talk about democratic election, we just had one in Lagos State, and Lagos State, and I think Oyo State. Now, I find it's very interesting in Nigeria. The Constitution says they should be democratically elected. What happens in practice? Every state has its own state electoral commission. So when APC or PDP is the ruling party in the state, is the ruling party that takes all the seats. So I ask myself, what is the difference between that election and the appointment? Because see, what happens in practice is the governors, most governors are emperors of their state. They determine who is the councillor, they determine who is the chairman. So is the governor who will determine the councillor, who will determine the chairman, then hold an election. So what is the difference between that and the governor just appointed somebody administratively. So that's where we find ourselves. But the local government council also has powers to make laws, because the laws setting them up must provide for their establishment, must provide for their structure, must provide for their composition, must provide for their finance, and must provide for their function. So in the local government council, you also have the three arms of government. The result is laws made by the National Assembly are called acts of parliament. Laws made by states are called laws. Laws made by local government council are called bylaws. So you have a fourth schedule in the Constitution that provides for the main function. So if a state government makes a law establishing a local government council, like I said, that law should provide for functions. Other than that, those functions, the fourth schedule of the Constitution has listed the powers of every local government council in Nigeria. Things like marriage, death, naming of streets, shops, licensing of. These are things that primary schools are things that every local government should do in Nigeria. So in sum, these are the three levels of government in Nigeria and their powers to make laws. Thank you.
Thank you, sir. Well, it's very interesting to see how the Constitution circumscribes lawmaking in Nigeria, but also to have some insights into the political wranglings that there are. I just have a quick follow-up to that question.
Yeah.
So you mentioned that the schedule to the Constitution sets out the items that are on the exclusive legislative list, which are 60 number, and the items that are on the concurrent legislative list, which are 30 in number. So what happens if an item is neither on the exclusive legislative list?
Thank you very much. Thank you very much. Yes. That is what we refer to as an unwritten list. So when an item is neither in the exclusive list nor concurrent list, it's called a residual matter. A residual matter. Now, a residual matter is left for the state government to make laws on. As we'll find in the course of this conversation, when we discuss the Arbitration and Conciliation Act, we'll discuss this issue of whether arbitration or conciliation is in the exclusive list or concurrent list, and therefore whether it's a matter for the federal government or the matter for the state government. Yes, thank you for reminding me. Yes, right, it's called a residual list. It's not written. So any item not among the 68, like you said, not among the 30 in the exclusive and concurrent respectively, is a matter for the state government. Thank you.
All right. Thank you very much, sir. Yes. And I can't wait for us to get to that point. Okay, so again, we last week we started talking about some of the complications of lawmaking in Nigeria, and last week we were discussing the sort of competition between agencies, and today we're discussing the competition between levels of government. One area where we've seen this has been the origination of bills. Where do bills come from, and how are they introduced into the National Assembly? Because sometimes we have heard of one bill in the House of Representatives and a competing bill in the Senate, and one doesn't really understand our process.
Yes, thank you. Now, a bill is a proposal that is sent to a lawmaking house for passage into law. So it's a proposal. In the Constitution, we have Section 58 dealing with bills passed by the National Assembly. We have Section 100 dealing with bills passed by the State Assembly. The procedures are essentially the same. Now, the power of any lawmaking body to make laws is exercised by bills passed by the assemblies and generally assented to, because the president can withhold that, but generally assented to. Now, how does it work? Let's start with the National Assembly. For me, I would prefer that the same bill is before the Senate and the House of Rep on the same subject matter. But in practice, from what I find from the study we carried out, you find that On the same subject matter, there are 2 different bills in Senate, 3 different bills in House of Reps. And last week, I talked about clearing house. I still believe that this is a duplication of efforts, because I know that members are anxious to be seen as sponsors of bills, but I think there's a need to harmonize this. So how it works is, if a bill starts from, say, Senate and is passed into law, that bill is sent to the House of Representatives to also go to the reading, first reading, second reading, third reading, committee report it, and pass it to law. Now, this is where we are now with the PIB and the electoral amendment bills. The separate chambers have passed them. The law is, these bills require the assent of the president, or if within 30 days he withholds assent, it can be vetoed by the House. So, but the Senate will not send its own bill directly, nor the House of Reps. So they usually meet to harmonize. So it's one bill that leaves the National Assembly for the presidential assent. So I expect that when they are back from their break, the National Assembly will now call a conference to harmonize these various positions on the petroleum industry bill and the electoral amendment bill. So it is when they harmonize a bill into one bill that it is sent to the president for assent. Now, the president has 30 days to signify that he's assenting or that he withhold assent. 58.5 says, if he withhold assent, the bill is again passed by a 2/3 majority and it becomes law, in which case it does not require the presidential assent. Many years ago, I don't article in this area, when you say the bill is again passed, what is the meaning? Does it mean you start from first reading, second reading, third reading, committee stage, report stage? What does it mean when you say the bill is again passed by the National Assembly? But the law is, once the president withhold assent, the National Assembly can veto it. And I ask myself, this night assembly, can they veto any bill? I doubt now. The 8th Assembly will do that, but not this now. I actually see this net assembly as a department at the bill. I don't see it as, they don't have the lever. How can the president withhold assent? And you know, if I may digress, I watched the debates on both the petroleum industry bill and the electoral bill. I just work for this country. The deputy speaker of the House who chaired the session is from Wase. He used Wase, local government, that in Wase, they have about 20% interconnectivity. He used that to convince somebody from Sulere local government. And it is strange that the certain states, somebody from Lagos State, for instance, how can somebody from Lagos State vote against electronic transmission of results? Somebody from Wase. So until Wase is ready, if it's in 20 years' time that Wase will have full connection or 80% connection, that is, so these are things we suffer in the country as a result of being a federal government. I do not see how Wase, I know Wase, I live in just, how Wase can be a basis for determining what somebody is ruling. That's where the speaker comes from. So that's the local government. So APC voted along party lines, not along what is we know is obtainable. In fact, in my area, we have disowned our senator who voted, because in our area we have the interconnectivity. So that anyway, that's a digression. But let's wait and see how they will harmonize these bills. But the point I'm trying to make is, if a bill is passed by the House of Reps and it's passed by the Senate, they have to meet to agree on one bill. That is the one bill that is sent to the president for assent. And he either assent or withhold assent. If he withholds assent, there are powers given to the National Assembly to veto that assent. Thank you.
Thank you, sir. For those who may not understand the the illustration that Prof just gave, that's about the contestations of the ongoing reforms of the National Electoral Reform Commission bill, and about whether Nigerians, whether the commission would be given the power to automatically transmit the results of elections that are done via online,
electronically,
electronic voting, as opposed to manually collating the results. And interestingly, I've also lived in Plateau State in Jos for a while, and so I understand the differences that you're drawing here. Thank you. But so I just want to explore this notion of the clearinghouse, because again, it follows the thread from our conversations of last week, and you know, when we were discussing the evaluation of the successes of the report that you presented in 2016. We want to better understand the responsibility of the Nigerian Law Reform Commission, as well as the relationship between this commission, the lawmaking process, and NASPA that was introduced into to assist the National Assembly.
Okay, I will start with the Nigerian Law Reform Commission. Now, the powers of the Nigerian Reform Commission, which are now referred to as commission, they are statutory. Now, if I want to ascertain how a statutory body functions, I look at the powers. Now, Section 5 of the Nigerian Law Reform Commission Act deals with the powers of the commission, and it says it's the duty of the commission to check and keep under review all federal laws with a view to their systematic and progressive development and reform in consonance with the prevailing norms of Nigerian society, including, in particular, the codification of such laws, elimination of anomalies, repeal of obsolete, spent, and unnecessary enactments, the reduction in number of separate enactments, the reform of, in other words, it is the duty of this Law Reform Commission to reform our laws. How does it do this? Subsection 2 provides that it's done in 3 ways. The first way is the Attorney General can send a proposal to the commission for purposes of reform of our law, codification, revision of our laws, or the commission by itself can send a proposal on law reform. Lastly, the Attorney General can send recommendations to the commission to work on any area of law, either substantive law or procedural law, and to draft laws. Like we said last week, the CAMA 1990 is a product of the Nigeria Law Reform Commission. In fact, at that time too, there were so many laws that they are products of the Nigeria Law Reform Commission. But if you ask me today to identify any particular law that is a product of the Nigeria Law Reform Commission, I cannot. I do not know any. Because they have challenges, like I just said now, the commission is a parasitical under Ministry of Justice. So when they draft bills, the bills are sent to the Attorney General. It now depends on what the Attorney General does with the bills. And if the bills get to the Ministry of Justice, it will undergo their bureaucratic process, sent to the Federal Executive Council for approval. Then the bill is transmitted directly by the President to the National Assembly. Now, what happens is when a bill is sent in a particular legislative session, like the 8th Assembly, if that bill does not become law within that session, the next Assembly will not treat it as an executive bill unless the President resubmits it. I'll give you an example. We were talking about reform bills last week. I said I was involved in the drafting of the, we have the Post and Abos Bill, Nigeria Railway Bill, Nigeria Postal, Nigeria Roads, Nigeria Funds Bill, NEWA Bill. There are about 50 bills that were sponsored by BPE. I was involved in following up in the Ministry of Justice. I assisted in preparing the council memo for the bills to move from Ministry of Justice to the Federal Executive Council. Then the Executive Council approved them. They were sent to the National Assembly. Because they were not passed in the year they were sent, the bills are floating in National Assembly. So you find now that these bills now become private members' bills. Like I said, unless they are submitted by the executive to them, then let me quickly do a line between government bills and private bills. They are called executive bills. Executive bills are bills emanating from the executive. And in this case, they come either directly from the president or from the attorney general on the authority of the president. Then private members like you can propose, talk to your lawmaker, talk to anybody you know, you draft a bill and it becomes, every bill must have a sponsor because you are not a legislator. So even if you are very good at drafting, when you finish drafting, you must look for somebody who will introduce the bill to the House for first reading. So every bill must have a sponsor. So what were otherwise government bills, because they are not passed during the tenure of the assembly, they'll be floating. That's what happens to the Arbitration and Conciliation Act that we're talking about shortly. That bill has been in National Assembly since 2007. In fact, I remember in 2017, we were looking for a sponsor. We then found this is otherwise a government bill. The government bill. But because it was not passed in this legislative session, it became a floating bill that we started looking for a sponsor. We got a sponsor. Somebody must introduce the bill to the House. Like I said, we are not all lawmakers. So no matter how good you are at drafting, you must get somebody in the who's a member of the House that will introduce the bill. So that is my problem with the Law Reform Commission, that when they draft their bills and they are sent to the Ministry of Justice, they cannot control what happens to the Ministry of Justice. But that's why I'm proposing that we may need to amend the law, establish it then, to put time frames. That if a bill is drafted and sent to the Ministry of Justice, there should be a time frame within which that bill must be treated. And I agree that they cannot really control. But look at the Electoral Act and matters in court. So I think that there should be a timeline for the AG to process that bill for the Federal Executive Council, for Federal Executive Council to the National Assembly for passing into law. So until we do this, there's no way of appreciating the work. Just now, I have attended many workshops, seminars organized by the Commission, but I don't know the outcome of what they do because they cannot send a bill directly to the National Assembly. I even suspect now that some members of the National Assembly will go there and just pick a bill drafted by them. What should have been an executive bill then becomes a private member's bill. So to that extent, the Law Reform Commission is really involved in a reform of our laws because it's their key mandate. Now, they are supposed to be reforming these laws regularly from time to time. In some states, for instance, I did a job for Edo State government. Their Law Reform Act provides that their laws must be revised every 10 years in Edo State. But we don't have such a provision in the Federal Act. The Federal Act from time to time. In other words, our laws should be reformed regularly. And that should be better than Edo State government that exists 10 years. But like I said, we don't feel the impact. So I don't know. We don't feel the impact of what they are. I know they're very busy. Most of them are academic staff. They are my friends. I know them very well. I think their activities, but I think that there should be a way of making known to Nigeria what they do. Now, let's come to NASBA. You know, in the last presentation, I talked about.
If I may just pause you there, for those who don't know what NASBA is, it's the National Assembly Business Environment Roundtable.
Yes. Okay. Thank you. You know, at the last conversation, we discussed NASBA extensively. Now, again, at that last conversation, we talked about the reform we carried out. So when we finished our assignment, like we said, we are sponsored by DFID. We sent a report to the National Assembly. Our report was submitted in February 2016, but NASBA was inaugurated on the 16th of March 2016. And NASBA is a partnership between the National Assembly, Nigerian Economic Summit Group, and the Nigeria Bar Association section on business law. You know, lawmaking is a complicated process. The private sector, because Nigeria Economic Summit Group is driven by the private sector, while lawyers drive the NBA section of business law. So these two organs, they partner with the National Assembly to see to the passage of all laws that deal with the business environment. Don't forget that our study was informed by our ranking in the World Bank's doing business. So NASBA is concerned with improving the environment for doing businesses in Nigeria. And so, again, you asked at our last meeting whether we had a procedure for ensuring that our recommendations were implemented. Right. NASBA took on this challenge. In fact, it was where we presented our report. It was that day that NASBA was inaugurated, and NASBA has worked actively to ensuring that all our recommendations are implemented. If I'll quickly add, this CAMA that I just passed, NASBA acted as a technical committee to the Senate Committee on Trade and Investment. So what NASBA does, NASBA attends all public hearings, especially in the area of laws dealing with the business environment. Then NASBA offers technical support to all the various standing committees of the National Assembly. Now, what NASBA does, because I'm a member of the Governing Council, I know Bolale is complaining I'm getting involved in too many things. I'm a member of the Governing Council of NASBA. So what NASBA has done, all the business-related laws are broken into thematic areas. So NASBA has 12 thematic areas, and they all deal with laws on regulating the business environment. So the thematic areas include trade, arbitration and dispute resolution, regulation, public finance and taxation, investment, infrastructure. So, like I said, NASBA has 12 thematic areas. Now, in our report, it was the laws we recommended for repeal, review, reform were 108. Now, NASBA has been able to ensure that 26 out of the 108 were passed by the National Assembly, 13 were accepted to, and 13 declined. So NASBA is following on from where we stopped to ensure that all the business-related laws in the National Assembly are passed into law.
Okay.
I know that Bolale, you also work for. So tell us what you do for NASBA. Tell us. It's not only me. What do you do for NASBA?
Well, I only recently joined NASBA in 2020, and I am part of, I think, two or three thematic areas. The more active thematic areas are the ones that are on my mind right now. So there's one, the one looking at the arbitration, the reform of the arbitration law. And we recently had a meeting where we gave our opinions on one of the competing bills on arbitration in Nigeria. I know that we were also invited in the regulation stream to give some comments on the proposed electronic Naira bill that is going through the National Assembly And I'm hoping that in due course, I would be working more actively with NASBA to see how I can contribute along with my colleagues to law reform, commercial law reform in Nigeria.
Okay. We meet every quarter. Our next meeting is on the 26th of this month. We meet every quarter. We actually follow up. All these bills are listed for our consideration. We are briefed. We ask questions. Like the last meeting, I complained that these are reform bills. Be there. I left BP 2009. So all these reform bills have been there since 2008, and yet they are not being passed into law. Yeah, and we need them to reform the economy. Thank you.
Yes. Thank you, sir. Okay, so we have set the scene now. We have a much better understanding of the constitutional issues and the relationship between all the moving parts that many people hear about but don't understand. We now want to apply this to a live issue, and that is the reform of arbitration law in Nigeria. So can we start by you providing us with a snapshot of the current legal framework for international commercial arbitration in Nigeria? I know that there is a lot of domestic arbitration, but I would like to talk more on the international commercial arbitration framework.
Okay, well, like you rightly observed, arbitration can be domestic or international. When is an arbitration international? You will find an answer in section 57, sub 2 of the Arbitration and Conciliation Act 2004. It says, an arbitration is international where the parties to the agreement have their businesses in different places. In other words, where an English company is entering into a contract with a Nigerian company and there's a dispute, because the Nigerian company has its place of business in Nigeria and the English company has its place of business in the UK. If there's a dispute, that is an international arbitration. Now, it can also be international if the place of arbitration is different from the place of business of one of the parties. Or it can also be international if the substantial part of the contract is to be performed in a place other than the place of business of the parties. Lastly, when all this fails, we look at the legal system that has the closest connection with the transaction. Now, simply, if you have done conflict of laws, the connecting factors, what factors connect a particular transaction with a particular legal system. So these are all connecting factors. Looking at the place where the contract is signed, looking at the place where the contract is performed, or looking at the legal system that has the closest connection with the subject matter. Now, what happens if you have more than two places of business? The law, I think, care of these two, that we will now look at where the substantial part of the contract is carried out. The law continues. Assuming you don't have a place of business, we'll now look at where is your habitual residence. So these are the factors that we look at determining when an arbitration is international or when it's domestic. Now, other than the Arbitration and Conciliation Act that has defined when an arbitration is international, Nigeria is a signatory to the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Secondly, Nigeria is a signatory to the 1965 Convention on the Settlement of Disputes between states and nationals of other states. So, to a large extent, Nigeria has the legal regime for international commercial arbitration. I'll talk about Lagos State briefly. Lagos State is one state that believes that the federal government has no business with arbitration. So in 2009, they passed their own arbitration law. They also passed another law called Lagos Court of Arbitration Law. So you have it's a regional center for dispute resolution in Lagos. So in Nigeria today, other than Lagos State, Rivers State also have its own arbitration law. So we have the federal one, the Arbitration Compensation Act. We'll talk about that, whether that is still valid shortly. Then that of Lagos State. So today in Nigeria, only Lagos State and Rivers State, they have modern laws of arbitration. As you'll find out shortly, all the other states are still using the 1899 arbitration law of England. That was arbitration ordinance in 1940. We'll talk about that very shortly.
Okay, well, we might as well, thank you. We might as well go into that. Can you give us, some insights into the legislative history? Because you've talked about, again, this is where having a federal system of government comes to play. So we've seen laws at the federal level and then laws at the state level. And then you've talked about the history of these laws. So how did we get to the place where we are now? What is the history?
Okay. At amalgamation in 1914, we had the
amalgamation of the northern and
southern Nigeria
protectorates.
In 1914. We had the received English law. One of such laws is the Arbitration Act of 1899 of England. So in 1914, that English Arbitration Act became an arbitration ordinance, and it applied throughout Nigeria. When Nigeria, Nigeria started as a unitary state before it became a federal government. By the time it became a federal government, this arbitration ordinance became the arbitration law of Western Nigeria, arbitration law of Eastern Nigeria, arbitration law of Northern Nigeria. And in 1963, when Midwest was created, it became the arbitration law of Midwest State. Because Lagos was a federal seat, a federal city, we had the Arbitration Act for Lagos. That act was in the laws of the Federation of Nigeria in 1958. So after the independence, we had the Federal Act for Lagos and arbitration laws for the various states. That was the position until 1988. On the 14th of March, 1988, the military government promulgated the Arbitration and Conciliation Decree. It was a decree, and if you know the history of decrees in Nigeria, decrees are superior even to the Constitution. So that law, if you look at section 58 of that decree, it provides that it shall apply throughout the Federation. I wrote an article in this area to ask, what about the state laws? And apply the doctrine of covering the field, that all those state laws are void to the extent of their inconsistency with the Federal Act. So we had the Federal Arbitration and Conciliation Decree that later became Arbitration and Conciliation Act. If you hear about ACA, I'm talking about Arbitration and Conciliation Act. That is where we were until May 1999. In May 1999, we had a federal constitution. We had a federal constitution. You can trust us lawyers. We started challenging the constitutional validity of the Arbitration and Conciliation Act. Now, Section 315 of the Constitution provides for modifying existing laws. The issue was the Arbitration and Conciliation Act an existing law? If it is, who modifies it? National Assembly or State Assembly? And the issue was, like I said earlier, the words are arbitration and conciliation. If you look at the exclusive list or concurrent list, you will not find arbitration and conciliation. So ordinarily, it's a residual matter. And so, like I said, that's why Lagos State feels that federal government has no business promulgating any law on arbitration. But this argument was on when the Orojo Committee was set up. And we had to again. I know Balali will complain again. I was a member of the original committee. So we had to look at the constitution very, very critically to see really whether arbitration and conciliation are residual matters. We then said treaties, like I talked about the 1958 New York Convention. I talked about 1965 Washington Convention. Now, it's only federal government that can deal with treaties. So treaties are the exclusive list. So we said where there's international commercial arbitration that the issue of a New York Convention will arise, it's only federal government that can make that laws. We also look at item 62A, 62A of the Constitution. That item provides for competence of the federal government to make laws on anything that has to do with trade and commerce between Nigeria and another country. Then trade and commerce between states in Nigeria. We then said, let's look at the last item. Item 68 of that list is an omnibus list, empowering you to deal with any matter connected with other items. We said arbitration and conciliation are incidents of trade and commerce. They are incidents of trade and commerce. And therefore, a state government cannot make laws on trade between Nigeria and another country, nor trade between two states. So we resolved that, yes, the federal government can have a law on arbitration dealing with international arbitration and arbitration between states. Then the state government can have a law on arbitration dealing with domestic arbitration. What did we do? We drafted two bills, the federal bill and the uniform law for the states. Is that uniform law that Lagos state government took and passed into the arbitration law of 2009? Is that a uniform law that Rivers state government took in 2019 and passed that into their own arbitration law? So in Nigeria today, other than Lagos State, Rivers State, all the other states are still using the 1899 English Act. I'll be trying to tell the governors, or if I meet that, look, you guys are still operating old laws in your state, and nothing has happened. Again, our own draft for the federal law, we drafted this bill in 2006, when it was Chibayo Ojo, as Attorney General, that set up our committee. So we drafted this bill, and it got to National Assembly in 2007. Since then, the bill has been there.
Okay.
Yeah.
Well, that's since 2007.
Yeah,
so that's 14 years.
Yeah, the bill has been there. Yeah.
Wow.
Yeah.
Okay. So
and one other thing that occupied us Roger Committee was we were supposed to look at arbitration and ADR processes. Now, among scholars, there's no agreement on the meaning of alternative dispute resolution. What does ADR mean? For me, it raises jurisprudential and conceptual issues. We'll start with the acronym. A. What does A stand for? Does A stand for alternative, appropriate, amicable? What does it stand for? Okay, let's forget about the acronym. Is arbitration part of ADR? Is arbitration part of ADR? Now, for me, it depends on how you define ADR. If you define ADR as alternative to litigation, then arbitration is part of it. But if you define ADR as a dispute resolution mechanism that is non-binding, arbitration is binding. So if you define it that way, we're talking about mediation, conciliation. Some scholars argue that this argument is academic. I don't. I'd like to ask, what is the primary forum for dispute resolution? So before we know what is alternative, what is the primary forum for dispute resolution? Is it litigation? I don't think so. So if a client enters your office and there is a dispute, your first forum is settlement. Some of us argue that the first forum is settlement or reconciliation, not litigation. So if the first forum is conciliation and settlement, then alternative to settlement and reconciliation, not alternative to litigation. So again, like I said, it depends on how you define ADR. And the definition is compounded by many factors. Those of us who are in this business, we see ADR like a river with many tributaries. Now, when you have a process that the definition of ADR includes unilateral action, private judging, expert determination, med-app, app-med, ombudsman, early neutral evaluation, mini trial, dispute resolution board, dispute adjudication board. How do you describe that? How do you define that? How do you define that process? Because all of them have different processes. How do you define it? So for me, it's not settled. I still see ADR like an uncompleted building. It's just work in progress. So for me, my position is ADR should not include arbitration. But like I said, you are entitled to hold your view as to whether, like I said, it depends on how you define ADR. If you say it's non-binding, ADR, arbitration is binding because there's an award. See, some of us see these processes of resolving disputes in many ways. You start from negotiation, where the parties do not need the intervention of a third party. So it's the parties that negotiate themselves. You move to mediation conciliation, where the parties will engage a third party who will assist them. A mediator or conciliator decides nothing, awards nothing. So he will merely assist the parties. Then you move to arbitration, where the arbitrator will resolve the dispute and give an award. So it depends on how one sees this process. That's why if you see some adverts for training programs, you see ADR and arbitration. Because of this argument that arbitration is strictly not, like I said, it depends on how you define ADR. But for me, I like to go the way of ADR and arbitration because the definition of ADR is a bit difficult.
It's very interesting to hear you unpack those issues, and these are matters that go into how we perceive of these dispute resolution mechanisms that there are, and it is designing effective frameworks has been the task of the arbitration world. And we have seen, the Singapore Convention added to the matrix of conventions.
I'll talk about that shortly. Yeah.
Yes, that we have. So, you have pulled together so many of the themes that I would like us to talk about, and I'm not. I would need some help or assistance as to how to proceed. So we've talked about the challenges to reforming the Nigerian Arbitration Act, and we've talked about the constitutional issues, and we haven't really talked about the competing deals that we have had.
We haven't. And whether our framework is effective for international arbitration. Let me start with that, whether our framework is effective for international arbitration. No, when the arbitration decree was promulgated in 1988, it was a blend of the 1958 Arbitration Act and the 1985 UNCITRAL Convention, UNCITRAL Model Law on International Commercial Arbitration of 1985. Don't forget, UNCITRAL is not concerned with domestic arbitration. That's what it's called, UNCITRAL Model Law on International Commercial Arbitration. So our Arbitration Act of 1998, like I said, was influenced by this modern law. So to that extent, what we have today now is effective for international commercial arbitration. It's just that it is out of date. Now, we have the bill before the National Assembly that we drafted in 2007. By 2017, we took that bill again. Again, I chaired a committee that drafted it, and at the National Assembly, I presented the report of the committee to the Senate committee that was looking at the bill. At the presentation, we gave a background to the bill and the fact that the draft that was before the National Assembly, when we finished in 2017, it was sent to UNCITRAL. It was sent to UNCITRAL for their review. UNCITRAL made comments. We want to ensure, in 2006, UNCITRAL amended the 1985 Act. So we had to ensure that the bill of 2017 was compliant with the UNCITRAL model law of 2006 and other laws, because if you look at the bill, you find that there are provisions in that bill that are not in UNCITRAL. For instance, UNCITRAL uses the word place of arbitration. Because of the confusion that creates, in this bill we use seat of arbitration. UNCITRAL does not provide for emergency arbitrator. In this bill, we provide for emergency arbitrator. UNCITRAL does not provide for third-party funding. In this bill, we provide for. So we have a bill that is very, very comprehensive that can cope with international commercial arbitration. We were talking about.
So the competing bills was the other thing.
Good. Now, I keep stressing that this bill we have in the National Assembly now was drafted in 2007. By I think 2011, there was a bill that we had was in the National Assembly, and there was going to be a public hearing on the bill. We say which bill other than our own bill? We found there was a bill titled National ADR Regulatory Commission Bill 2011. We went to war. I led the war. I was at the war front. So we did a presentation to tell the National Assembly that we don't need that arbitration ADR processes are consensual. We don't need a regulator. What we are trying to do is to be an arbitrator or a conciliator. You have to get registered. So we don't need any regulation. These are areas that are party driven. We don't need any regulation. So in 2011, we keep that bill. Then last year, I found out another ADR bill. I went to war again. I said, look, this bill cannot stand. And in looking at the scope of the ADR bill, they said the ADR bill, the focus would be on certain civil disputes. I checked the definition section of that bill. There's no explanation for certain civil disputes. Now, since the UNCITRAL model law on international commercial arbitration of 1985, commercial is a word that has been defined in the UNCITRAL model law. If you look at that Article 1 of the modern law, you find the definition of commercial. In our Arbitration and Conciliation Act, Section 57, Sub 1 also defines commercial. And that section says the word commercial should be given a broad definition to include all commercial relationships, whether contractual or not. All commercial relationships, whether contractual. In other words, the bill covers both pure contract and tort. So if we have a bill that has defined commercial arbitration to govern contractual liabilities and tortious liabilities, what is the ADR bill going to do? What is certain civil disputes? What is certain disputes? So that is not done yet. We only made the representation to NASHBA. We are meeting on the 26th of this month. I'm sure we'll take a final position on that bill and inform the National Assembly of our position. Then I didn't quite finish with the history of the bill for the National Assembly. In 2017, we got close to getting the bill passed. In fact, Senate passed it, awaiting concurrence by the House of Reps. When I saw what the Senate passed, it was worse than the old law. So we intervened. We stopped it from being processed at the House of Reps. That's how the matter dragged on until it was not passed. Now, by 2018, you know, in 2002, Constitutional had a modern law on international commercial conciliation. And in that bill, Constitutional defined conciliation to include mediation. In other words, for Constitutional, conciliation and mediation have the same meaning. Now, by 2018, Constitutional amended that model law and now adopted Constitutional model law on international commercial mediation, and also provides that the definition of mediation includes conciliation. When we realize that, and our bill had not been passed, what they called it, then you refer to the Singapore Convention. Yes. So there were two main instruments in 2018, the Singapore Convention and this model law. So we withdrew our bill to provide for constitutional model law of international commercial mediation and the Singapore Convention. Singapore Convention is to mediation what the 1958 New York Convention is to arbitration. So what we have now incorporates the provisions of the constitutional model law and the Singapore Convention. So our law, if passed, we are fully constitutional compliant and can compete with any arbitration law anywhere in the world. Thank you.
Okay, that's great to hear. Well, I would not take this opportunity to, but I would just flag it up that the bill that you're going to sit over to discuss under NASBA, under the aegis of NASBA, also contained something about traditional arbitration.
Yes.
No, that would take us far out.
Okay.
But this is something that I hope that we can pursue at some later date. But so that we can continue and wrap up these conversations quickly, I know you have talked about the Oroja Committee, which was the National Committee on the Reform and Harmonization of Arbitration and ADR Laws in Nigeria.
Yeah.
As always, because many of these committees are not well known, I like to have some conversations about them because so many people contribute so much to law reform in Nigeria who are, as far as I'm concerned, unsung heroes, such as yourself, that we have to dig out. I want you to tell us a bit more about this committee. So who were the members, what were the terms of reference, and what were some of the key recommendations, bearing in mind that we have very little time left.
Okay. We had two main terms of reference. The first one was for us to review the laws on arbitration and ADR in Nigeria with a view to proposing necessary reform and to bring the laws in line with modern trends. Two, to perform any other acts we deem necessary to achieve that objective. Now, so there were just two terms of reference. Who were the members? Our committee was chaired by the late Honorable Dr. J. Olakule Orojo. Then other members are His Excellency Prince Bola Ajibola, Chief Mrs. Chinwade Oyekunle, Mr. Mohammed Bello Adoke, at that time was not a senior advocate of Nigeria, Mr. Pascal Madu, Dr. Paul Idornigie, at that time I was not a professor, I was not a senior advocate of Nigeria, Mr. Kevin Wosu, Mrs. Donyi Rosriver, Mr. Tony Amokeodo, Mrs. Bakare, Mr. Dele Bengore, Mr. Tude Busari, Chief Bola Akinola, Chief J.K. Gazama, and our secretary was Tunde Pakoholu. It was a very powerful committee.
Sounds like it.
Yeah, because for me, Dr. Rojo is a leading authority. He has a book that was published in 1999, himself and Ojomo. That book is still a leading book on arbitration in Nigeria. So for me, working with Orojo was very, and Chief Oyekunle was involved in the drafting of the 1985 model law on commercial arbitration. She was a director in the Ministry of Justice. she represented Nigeria in several meetings of procedural. So, and Honorable Peace Bola Jibola, in fact, my first time out of Nigeria for an arbitration, they just asked me. The only person they knew then was Jibola. Yes, that's the only person they knew internationally in arbitration. But we now have many people who are very strong internationally, like Chifayo Ojo, Funke Adekoya, SAN, Dorothy Ufort, why many people now are very, very strong, who are even on the ICSID panel. Yeah.
If I could sneak in a bit of nerdness, Chief Bola Jibola was also he was involved in the creation of the Nigerian Law Reform Commission.
That is true. Yeah, he was the Minister of Justice.
He was, yes.
So the Minister of Justice. Like I said, Law Reform Commission is under the Minister of Justice. Yeah, yeah.
Yes, all right. So
yeah.
those
now,
are my...
Now, our recommendations were essentially two. Given the confusion created by the 1999 Constitution as to the basis of Arbitration and Conciliation Act, after we examined this Article 62A and Article 68 of the exclusive list, we resolved that the federal government has the constitutional powers and competence to make law on arbitration and conciliation only in respect of trade and commerce which are international or intersea. Then two, when the states have competence to make laws on domestic arbitration. So what did we do? Like I said, we drafted two bills, one for the federal government, one for the state government. It's the one for the state government, like I said, Lagos and Rivers States have adopted today. They now have their own laws on arbitration.
Okay, thank you very much for that quick summary. And I will just take you to the last question for today.
Okay.
So what expectations should we hold for the reform of arbitration laws in Nigeria in the near future?
I think that is promising. If you look at the Section 3 of the National Judicial Institute Act, it gives power to the institute to train judges. Because for me, the problem with arbitration in Nigeria is the courts and we lawyers. The courts, we lawyers. Most judges do not or did not appreciate their roles in arbitration, because if you look at Section 34 of the Arbitration and Conciliation Act, it provides that no court can intervene in arbitral proceedings except as provided by the Act. Now, some judges see that as ousting their jurisdiction, and it's settled. Many judicial divisions that arbitration does not oust the authority of the courts. So the NJI is empowered to train judges. So it's increasingly training judges, and judges are beginning to appreciate their role in arbitration. Especially Section 30 of the Act that provides that an award can be set aside if an arbitrator has misconducted himself. Unfortunately, this law did not define the word misconduct. So any lawyer who has lost at the arbitral proceedings rushes to court to allege misconduct against us. And so this has been a problem of arbitration. But luckily, I think in 2017, the former Chief Justice of Nigeria, Justice Walter Onogen, sent a practice direction to all heads of courts, to make laws, in the Constitution, all the federal courts, all the courts established have power to make practice directions. So, Honorable Justice Onogen, CJN, now directed all heads of courts to ensure that there are practice directions on arbitration, that the court should not entertain any suit where the parties have by consent agreed to go for arbitration. That if such a suit comes, the court should decline jurisdiction. And so with this, increasingly, the courts are beginning to appreciate arbitration. So for me, The future is bright, but many of us lawyers need to train, because just now the market is polluted by people. See, we lawyers are very arrogant. Every lawyer thinks he's an arbitrator. I say, no, you're not an arbitrator, you're just a lawyer. So I urge lawyers who have interest in this area to train, because what I'm seeing, they are given awards that are not reasoned, and so awards are being set aside. I have been to arbitration since 2002, and I do it regularly. None of my awards are set aside. So I urge lawyers who are interested in policy arbitration to train. Come for training. We have the Chartered Institute of Arbitration in Nigeria. We organize training regularly. They should train on the law and practice of arbitration. Like I said, there's a future for arbitration. See, when it comes to international disputes, no foreign investor would like to go to your court. No doubt about that. No foreign investor will. So arbitration is still the option of foreign investors when it comes to disputes. Thank you very much.
Thank you very much, sir. Thank you very much for unpacking the thorny constitutional issues in commercial law reform in Nigeria and the division of powers between the various levels of government. Also for giving us a first-hand account of arbitration, the arbitration law reform journey in Nigeria. And we look forward to seeing the finished product, I'm sure, as much as you do. And I would also say that I look forward to our final discussion, which I think will be the most fantastic of the series, on your role at the BP and the impact of this agency on commercial law reform in Nigeria. And I hope that everyone can join us for that conversation also. Thank you very much once again, sir.
My pleasure.